Hello everybody, this is again General Introduction to Tax Law, now chapter number 10. So I want to talk today about rules of procedural law again and its importance, and let's start. What is it about? Well, the rules how to deal with a tax case by the authorities or by the courts, and such rules are important because if you want to have everybody treated alike, that only the taxation is determined by law, then you must exclude the individual discretion of the people involved as far as possible. Examples which you already know about are objections. There's a time limit for them, 1 month, and there is an assessment time limit or a deadline after which assessments can no longer be changed under no circumstances. Now, the basic problem is how can we ensure that the members of the administration do not abuse their power but follow the law, and that is granted by the right that every decision made by an authority can be reviewed by a higher juridical authority, so you can appeal to a court. The deciding person should be neutral. For example, if you can only appeal to the decision maker himself or herself again, then that person will usually be convinced of his or her decision and stick to it. So you can't reach a change. So the deciding person should be neutral, a judge or several judges acting together. Now, on the other hand, if everybody who is not happy with the decision of an authority can directly approach a judge, that's probably a waste of time of judges. It might be that the person in question just says, the authority in question just says, yeah, we took a look on our decision, thanks for the hint, we admit that was a mistake, we change it, and give in to your application. In that case, a judge would not have been necessary. And because judges' time is valuable, this is just a procedure, a way which the law prescribes. You just have first to ask the fiscal authority for a review. That is made by the objection. And if they stick to their decision and say, no, we don't grant your objection, and we formally reject it, then you have free the way to court, but only then. So if you miss to file an objection within the right period of time, also the way to court is blocked. So that leads to the following steps. A decision is made, you object within the time limit, and then either the authority says, yes, we accept the objection and we grant your application, or they reject it and taxpayer is still not convinced and wants to go on, then you file a lawsuit against the fiscal authorities in court. Now, if you can object, if you can fight against every decision and ask for revision by a court or so, that brings along a mass of questions. For example, what is a decision? You can go against the decision, but not against other things. So what is a decision against which one must grant you legal remedies, and what things are such a trifle that such a procedure is not necessary and a waste of time? Then, who should have the right to object? Everybody or only the persons affected by the decision? Now imagine everybody could object against every possible decision in this state. It would probably be a chaos. Then, naturally, again, short information on how long should one have the right to object, how should the time limit be calculated in order to be exactly the same everywhere, and not subject to the individual feelings of your tax officer, and which consequences should an objection have and which ones not. So you already have, just from the simple idea that everybody should have the right to protest against a decision which is regarded as wrong, already from this simple idea you have a long list of things which you have to regulate, if that is meant to work. First, what is a decision which can be objected to? There is a legal definition made for that purpose in paragraph 118 of the General Tax Code of Germany, the AO. My translation is every order, decision, or other measure based on public law, so not on a contract, which an authority takes in order to regulate an individual case in the field of public law, and which is aimed at generating immediate legal consequences for others or another person, is an administrative act. Now, example, taxpayer TP enters the office of the tax official TO. TO greets him with a polite, "Good morning." TP regards that as outrageous. It is already 15 minutes after noon. So it's a scandal that you still regard that as morning. That's insulting. You treat me as if I were a student still. For students, 12 o'clock in the morning is morning. I formally and officially object and want a formal decision from your superiors with an excuse for being greeted with good morning at 12:15 in the morning. Now the question is that a situation where you have the right to object, or do you have no rights at all? And the answer, ladies and gentlemen, try to have a look again on the definition. Every order or measure based on public law which is meant to generate immediate legal consequences. Now, greeting somebody, is that based on public law? No. Is it a measure which aims at creating legal consequences? Good morning, no consequence. So, where there is no consequence for you, you have no right to counteract that and to oppose it. So, might not be polite, might be a mishap, but has no consequences, and as it has no consequences for you, you have no right to object against that. Why must that be regulated? Why, ladies and gentlemen? Well, would you, if you had a chance, bother the fiscal administration with absolutely senseless objections just to make them suffer? And the answer is, we have 80 million people living in Germany. What do you think? If a percentage of only 1% is so unnice to want that, you would have 80, 100,000 unnecessary objections in situations like these. So naturally, you must restrict the right to give an objection to situations where that makes, or at least can make, sense. So things which have no consequences are not things where you can object to. Now, example number 2, taxpayer TP2 has calculated his income for this year as a loss of 10,000 from agriculture and a profit from business of 30,000. Now the fiscal officer comes to a different result. He corrects the figures. For example, he thinks that 5,000 revenue, which you booked as revenue from business, are rather to be regarded as revenue from agriculture. So his figures are a loss of minus 5,000 on the one hand and a profit of only 25,000 on the other hand. Now TP2 thinks that's not my figures. He's deviating. I want to object. Is that possible? And the answer is no. Why? Because in the end, you get a tax notice, and that tax notice is based on a total taxable income, in that case of 20,000. And that leads to a tax of approximately 3,000. Now, based on your figures, exactly the same outcome would have come out. 20,000 total taxable income, tax 3,000. So the deviation has no consequences. That the decision, what you have to pay, that's the decision. The rest is only reasons given for the decision. And now, if the decision is correct, it's no reason to object. And now our question was really, can you object against the different figures for the loss and the business income? And the answer is no, because the tax officials' opinion on what your loss from agriculture was and what your business income was have no immediate legal consequences for you. The only consequence is created by the tax official's decision how much tax you have to pay. This is the only fact in your tax notice against which you can protest in that case. All the other things are just blah blah, reasons given for the decision. But the decision is your taxable income is 20,000 and your tax to be paid is 3,000. All other things are not decisions, and so are not an object for an objection. Good. Taxpayer number 3 has been given his tax notice for the current year and his tax has been assessed at 12,000. Now, taxpayer 3 is an honest person and has recalculated this stuff and found out it should only be 11,800 euro. Can you object against this? And the answer is yes. Now the decision is paid 12,000 and 11,800 is less. So decision is regarded as wrong by you. You can object, and if you do in time, objection will be checked. Now taxpayer 4 has been given his tax notice for the current year and the tax has been assessed as 20,000. In the same letter, TP4 has been informed that he has to pay his amount within 1 month. Now the question is, how many administrative acts are here? 1 only or 2? They are on the same piece of paper, but is it 1 decision or 2? And the answer is, well, the decision how much you have to pay and when you have to pay are in principle 2 decisions which can logically be separated. So the fiscal authority could also have decided pay 20,000 but only in 6 weeks. So there are 2 decisions on the same piece of paper. And so if you object, you have to say against which of them you object. All the ones against you do not object can stand and remain valid. Yeah. Taxpayer 5 gets a tax notice which fixes his tax liability as 12,000 and states that his tax notice is only a provisory one because one didn't have the time to check the case thoroughly. So it's issued under the condition that the fiscal authorities reserve the right to redo the whole thing later. Is that 1 administrative act or 2 different ones? That means, can you oppose yourself against, let's say, only the clause that it's a provisory assessment and let the fiscal amount stand? Or if you oppose the decision, does that attack both parts of it? So the figures and the clause. And the answer is, think about it. Would you, if you think you are only provisorily informed about the facts, would you then have issued the same decision if it had to be definitive? The answer is probably not. You would either have set a higher amount or waited with the decision. So in that case, the 2 parts are so interconnected that the one is not imaginable without the other. If the situation is so that I can only provisorily decide, I would probably not have made a decision at all if I had not been entitled to making that condition. So you can't attack the condition alone without also skipping or attacking the number which was fixed. So this is one single decision, and it either stands or falls together. You can't logically separate them. But here you see which questions come up from time to time. Naturally, some people think, oh, I'm fine with the figures, but I want to get rid of that clause. I want to get rid of the later review. And then a court has to decide, is it one decision or can it be logically separated so that it is two decisions? In that case, everything which the taxpayer didn't attack stands and cannot be changed without specific reasons. So that makes a big difference. Now, who should have the right to object? Now imagine that taxpayer 3 has heard that taxpayer 4 has, due to a mistake of the fiscal office, been assessed with a tax which is too high. Taxpayer 3 is a very, very honest person and is absolutely outraged by the scandal that a fiscal authority asked too much money from somebody else, for example, €2 too much. Now, taxpayer 4 is relatively fine with the decision. Even if you inform him, well, fiscal authorities want €2 too much, then he just generously says, well, €2, what? Who cares about €2? Oh, they also need some fun. Let them have those €2. I'm not going to spoil my life for the next 5 years with objections and court procedures just because of them €2. Now, taxpayer 3 is just a very correct person and is not going to tolerate that, so writes an objection to the fiscal authorities. I hereby object against the tax assessment against taxpayer 4. That was too much, and that was not legal, that was breach of law, and then many pages follow with that, and that, and that, and that, and then he says, please change that, and he indeed is within the deadline. Now taxpayer 4 thinks, if I am fine with the decision against me, why should that be the business of somebody else? Taxpayer 3 should just mind his own business and not mine. So, and the law really says, well, you have no right to object against things which do not affect yourself. So taxpayer 4 has no right to interfere here into the relationship between taxpayer 3 and the fiscal authorities. You have to bother your own affairs and not those of others which do not affect you. So only the taxpayer, only the persons to whom the decision has a meaning, who are directly affected by it, to whom it is addressed, can propose themselves against the decisions. Others cannot. Otherwise, you would again have a chaos of millions of people writing objections against things which have no bearing at all for themselves, just because of idealism or just because they want to torture the fiscal administration with senseless objections. Yeah. So you can only object against any administrative act if you are personally affected by that decision. Okay. Yeah, who should have the right to object? Imagine taxpayer 5 has received a tax notice which sets his tax liability to 10,000. Now taxpayer 5 thinks the correct amount should be higher, namely 12,000. And taxpayer 5 is not only honest, but very honest. So he writes to the fiscal administration and objects against the tax notice. My tax is too low. I demand a correction. Is that possible? And the answer is, well, here no harm is done by the decision. You are treated better than you should be. Okay, that's not right, but where's your problem? You can only counteract or oppose by an objection the activity of an authority if it is doing harm to your rights, not if you are preferred. So no objection is possible if you can't bring forward that there is harm done to you. So you must bring forward that is doing harm to you. Variant. Now let's change the situation. Same situation, your tax assessment has been 10,000 and you think the correct amount should be higher, namely 12,000. Now taxpayer 5 is not an average person, but the member of a religious sect in which there is the belief that you are punished by God after your death and go to hell if you cheat. And if you do things which are not exactly in line with the law, and that will also happen if you don't actively cheat, but tolerate wrongdoings in your favor. So if others prefer you and treat you better than you should be treated, that brings you to hell. Now that taxpayer now writes an objection. You assessed me with a tax which is too low. That endangers my eternal life. It might be for me the decision between heaven and hell, and so your decision, if I don't object, that risks my eternal life in heaven and brings me to hell, at least in my belief. Could the taxpayer object? That's relatively hard. Because now somebody objects against the tax which is too low, but that person brings forward that for him that tax which is too low does a severe harm. Now one might have different opinions of if that harm is really existing, but that's always the case with objections. So if I were a judge, I would be inclined to hear that case. The taxpayer brings forward the wrong tax assessment does considerable harm to me. It violates my rights. So the interesting question is, if you are violated in your rights, must it be a violation in legal rights or not? In that case, for example, that taxpayer, if you just say, you are not violated in your rights if you are not violated in legally granted rights, that could limit the number of objections. But in that case, our taxpayer could even bring forward that religion is protected by the Constitution. So things which affect your religious belief and your faith there probably are legally protected rights or issues under the Constitution, so the case would not be so bad. One could even vary the case in a more interesting way. Taxpayer 5 is not the member of a religious sect, but the member of a group which is far, far more dangerous to the public. That is, he is a member of a political party and a candidate or a potential candidate to a mandate in a membership in parliament or a local city council or something else. And now taxpayer 5 says, if my tax is assessed too low and that becomes known, and it might become known because somebody might ask me to present my tax notice and disclose it to the public, then that might ruin my whole political career and it might ruin my credibility to the public. So that is my reason why that wrong assessment does severe harm to me, although it's in favor of mine. Surprise, such a case has never ever shown up in court up to now. But it would be highly interesting how judges then have to decide. Because naturally, here the taxpayer brings forward the wrong tax assessment does severe harm to rights which I have. They are not tax rights, but they are other rights. For example, the free exertion of your profession. And now a wrong tax assessment ruins the career of a person And by the way, it would be an excellent means for people who want to get rid of political opponents if somebody in an authority would be allowed to make a mistake in favor of that person. Because later you could always leak these facts. It's absolutely forbidden to leak information on tax cases, but things get forbidden because they must get forbidden, otherwise they would happen. So the information might then leak that for several years that candidate for a political position has profited from illegally low tax assessments. And so such a candidate could probably never get rid of the suspicion to be corrupt. So bringing forward that would probably also make an objection. You assessed my tax too low, an objection which is rightful, for which you have a right. But if you can't bring forward that a right of yours is harmed, then an objection is not allowed because it would be a waste of time. If the fiscal authority thinks you have to pay a lower amount than you think you have, that's not a question to waste the capacities of the bureaucratic institutions. That's just fine. One can usually rely on what they decide. You have no duty to object and even no chance to object to decisions in your favor, apart from the interesting theoretical cases which I just put forward. By the way, it's really interesting that in 100 years such a case has never showed up in a court. On the other hand, it would not be surprising. Why? Because if you just write an objection letter to the fiscal authority that you want your tax notice changed to your disadvantage, they would probably be happy and say, it's an idiot or a very strange person, but why not? So let's give in and assess the tax in the higher way. So that also might explain that even if there were such a case never has shown up in court. Now, that has never been decided. How long should one have the right to object? How long the right to bring in a complaint in court? And the answer is in both cases 1 month. You know that already. The objection period is fixed as 1 month for objections against a tax notice and other administrative acts of the fiscal administration. That's paragraph 355 of the AO. And after an objection has been formally rejected, so after you have written a mass of letters to the fiscal office and got a mass of answers, then sometime an official decision about your objection is taken. And then, if you receive that, you can appeal within 1 month to a court. And the reason is what is the reason? The reason is that state wants to be certain which money can be spent. So it makes no sense to allow you still to oppose a tax notice which is 3 years old without any warning, because then the money has still already been spent by the state, and so it would be difficult to hand it back if now suddenly all people can dig out cases which are years or decades old and now claim back money. So you must limit the risk that the state has to give back money which they receive. And so it must be relatively quickly clear if there is opposition to the decision or not, if it is accepted or not. And that is the reason for the 1 month period. So what should be the legal consequence if no objection is brought forward? Then naturally nothing should be changed. You should then be able to rely on the validity of that decision. That is regulated in the AO2 because it is again a procedural law regulation which affects the treatment of all tax cases irrespective of the tax which we speak of, irrespective if it's value-added tax or income tax or so. These rules are always valid for all taxes, and so they are outsourced into the general tax code, the set of rules which is valid for nearly all taxes at all together, apart and can only be deviated from if there is a special rule in the specific tax act. So 124 AO says an administrative act becomes effective or valid against that person for whom it is meant or who is affected by it in that point of time in which it's officially notified or communicated to that person. That's called Bekanntgabe in German. Sentence number 2, the administrative act becomes effective with that contents which is communicated. So in case that somebody expresses himself strangely or wrongly, you can't argue that the administrative act has that effect which you meant it should have. What counts is what is really written there and how a neutral educated reader can understand or would understand what you order. So you can't say I wrote A but I meant B, so you have to follow B. You can rely on what is really told to you. Now for our question here, far more interesting is paragraph 2 of section 2 of paragraph 124. An administrative act remains valid, stands, or in German is bestandskräftig, as long and as far as it is not revoked or cancelled, expired, or rendered ineffective in any other way. And the only exception is an administrative act which is nil and void does not become effective. So if you get an administrative decision communicated which is absolutely nonsense, then you don't need to follow it. But that naturally also has to be regulated. So that legal rule means 124 AO, if you do not object against an administrative act, it remains binding for you and you can assume it's legally correct. And it would, in most cases, also bind the fiscal office for the future as long as it is not changed, and a change is not always legally possible. We are going to talk about that later. Now you should know the only exception, if an administrative, is nil and void because it's absolutely senseless. That is the case if such an administrative act has extremely severe mistakes, and this fact is immediately evident to every reasonable reader. That's approximately the definition given in paragraph 125 AO. So normally one assumes that an administrative act is binding and correct. Now, if you think it's wrong, then you have to object and lay out your case to the fiscal authorities, and they have to decide. And if they don't accept your objection, then the court has to decide. So every case where a debate is necessary about correctness is not a nil and void case. If even theoretically it could be imaginable that your tax notice or the other administrative act might be correct, then it's not a case where it's nil and void. So in that case where it theoretically could give a case, where it could be true, then no nil and void case, then objection is necessary. So that is usually misinterpreted by people. For example, see here the example taxpayer 6, always for a low income earner, 20,000 a year at most. Now he got a tax notice, over 100,000 euro taxes to be paid. The question is now, is that a valid decision against which you need an objection, or is it so senseless that you don't need an objection, that it can be regarded as nil and void? And the answer is, well, there could be a rich person who lives in very modest conditions just to deceive the outside world about being rich. There could be somebody who has 1 million of income which others do not see, and so it could be true. It depends on the facts of the case. You don't immediately see that this decision must be under all circumstances wrong. So that decision is valid and must be opposed by an objection. You cannot otherwise attack it. You cannot just treat that's rubbish, that must be wrong, fiscal authorities made a mistake. No, here you must bring to their attention that you think it's a mistake, and there must be an objection and a debate. Now, when could perhaps something be nil and void? Now imagine a very extreme case. The fiscal office made a party and they drank and celebrated and they got in a very, very nice mood, and so somebody took a letter and they just gave in to their inclinations and wrote you a letter that due to suspicion of tax fraud, hereby you are sentenced to death and the execution is going to take place on the 1st of April next year. Congratulations. In that case, ladies and gentlemen, you received an administrative act which is nil and void, because everybody in Germany who is familiar with the execution of legal orders knows that Germany has no capital punishment. There is no death penalty in Germany, so no German authority could ever condemn somebody to death. So that can only be rubbish. By the way, naturally you would, just for reasons of safety, object against that decision nevertheless, because you want them to admit that it was rubbish. But if somebody, for example, a policeman, shows up or gets that administrative act into his hands, he will probably read them that, what's this? Death penalty. That's rubbish. Who wrote that? But he will probably not begin to execute that decision. And that is the character of being nil and void. A bit more complicated. You get a similar letter from somebody in the fiscal office. Dear taxpayer, because you committed tax fraud and we can prove that, you hereby are sentenced to 5 years in prison because of tax fraud. Now, if you look up 370 AO, you will find out indeed the maximum punishment for tax fraud is 5 years imprisonment, at least in the average cases. Nil and void or valid? And the answer is everybody in Germany knows. Who can give you a prison sentence? Can it be done by an authority or must it be done by a court? And the answer is the fiscal authority can not do that. Only a court can condemn you to an imprisonment sentence. And there will be a court hearing where you show up as a defendant and where you are accused and where you can have the right to take part and to tell them your opinion, what really happened. So without a fair court trial, there will be no sentence. And so everybody who sees that letter, fiscal office, gives a prison sentence. The fiscal office can't give a prison sentence, so that would be a decision which is nil and void. Nevertheless, by the way, in case that letter comes into the hands of an idiot, it would be nevertheless recommendable to apply to the fiscal authorities to give you an attestation that this letter was indeed rubbish, so that you can prove it if an idiot shows up and wants to bring you to prison. One never knows. Good. So that's clear here. How should time limits be calculated? That was our fourth question. So if you need to object within a certain time limit, then you must know how you must calculate that. And the thing is, that must be absolutely exactly defined, because otherwise, if you leave the decision, if a time limit has been kept or not kept, to the local fiscal officer, then the people are no longer taxed according to the law, but according to the mood of the local tax officer. 1 minute delay, let's forget about that. 2 minutes delay, let's forget about that. Somebody else says 7 days delay, what's 7 days? And somebody in another city says, no, 7 days is a considerable delay. And so the first thing you have to learn, a time limit is a time limit. A delay of 1 second is already a cutoff. And if you want to show tolerance, because you say, an exception should be granted, then the conditions for that should be normed in the law, because otherwise people would be treated differently according to the individual mindset of the tax officer dealing with their case. And that would be taxation based on coincidence and not taxation based on the law. And so definitively you must have strict rules to calculate time limits. The exact end must be known and the start must be regulated. So you need clear rules on that. An example. Imagine the objection period begins with the official notification or communication with the Bekanntgabe of the administrative act and ends a month later. How would that be done? Now the postman brings the mail with the tax notice to your mailbox on the 2nd of April, and as you remember, that was 13 hour 1 p.m. and 17 minutes. When does the deadline end? For practical reasons, it's relatively difficult if something happens during a day to find out the exact minute when that happened. And that exact minute could, if that starts the deadline, then also the deadline would end during a day. And that's always very, very difficult to determine if then something still happened at 1 p.m. and 16 minutes, or if it happened, if you handed in a letter into a letterbox at 1 p.m. and 18 minutes, so that a deadline was passed. And so for practical reasons, German law has a rule that in case of a period that is started by an event, the starting point for the calculation of the deadline always begins at midnight, at the end of that day only, because then that makes senseless all debates if the postman came at 1 p.m. and 16 minutes, 1 p.m. and 20 minutes, or 1 p.m. and 30 minutes. Whenever the postman came on the 2nd of April during the day, the deadline starts to run at midnight at the end of 2nd of April. That makes the calculation of the deadlines far more easy. And so in our case, the objection period begins with the end of the 2nd of April, so at 24 o'clock in the night, and runs an exact month, so till the end of 2nd of May, 24 at midnight. So you can file your objection from the beginning of 3rd of April, 0 o'clock, to the end of 2nd of May, 24 at midnight. That makes things easier. Now, when somebody missed the time limit, sometimes it's rather harsh than to say, okay, a minute late, lost your rights. And now, if one wants to show mercy, that should not depend on the mindset of the individual tax officer. So there are strict rules for that too, otherwise it would be unfair. You said I missed the deadline by 1 minute because I was run over by a bus when I went to go to the fiscal office and I woke up in hospital. And then I immediately sprang out of the hospital bed, took my objection letter, ran to the fiscal authorities, tried to put it into the letterbox, but was unfortunately, because my clock was not correct, I was 1 minute late, so my objection could not be treated again, was beyond the deadline, and I lost the right to claim back 1 million in taxes. And then somebody else might say, oh, that's interesting, because I was also run over by a bus. I had the same fate. I also managed to arrive at the letterbox of the fiscal administration 1 minute too late, but my fiscal officer said, okay, that's not your fault. You did your very, very best. And So let's forget about that 1 minute. I'm going to accept your objection. In that case, one would lose 1 million, the other would not, just because their tax officers have different ideas, and that's not a tolerable status. So for that reason, there are strict rules when a delay or when missing a time limit can be made acceptable or not, and so you have to regulate that. The first idea is you could ask the fiscal authorities to prolong the deadline, and the answer is that's not possible, because the deadline can only be prolonged by the person who set that deadline. And for example, the objection period is not set by the fiscal authorities, it's set by law. And the fiscal authorities cannot change the law. They would like to, but the law wants to remind them wherever that is possible, no, you are not the bosses, you are civil servants, and you should serve and obey, not rule and command. So it's not allowed for you to change a deadline which is set under the law. So we have to think about other solutions for that, which reminds them of the fact you are not allowed to change the law. So what we could logically think about is another solution to allow treating the objection, although it was delayed because it was not taxpayers' fault. That's called reinstatement into the rights which were lost. So they are given back to you. You lost the right to object, but the right is granted back to you because it was not your fault. So officially the deadline is passed, but it does not matter in your case. The rules on reinstatement can be found in 110A0. If someone was without fault hindered in keeping a deadline which was set by law, then on application that person has to be reinstated into that person's rights. Faults of a representative or an agent acting for that person have to be regarded as faults of that person himself or herself. So you can't talk yourself out of being responsible for a mistake by saying that mistake was not made by me, but somebody else whom I ordered to act for me. If you select the wrong persons, your problem. No? The faults made by a person whom you gave an order are your faults. Good. Now, if you bring forward that you missed the deadline without your own fault, then the application has to be made shortly or quickly. So within a month after that obstacle falls away. And you have to bring forward the facts which are relevant to decide on the application. You have to make them plausible either in the application or later during the procedure and decision over your application. And the action which you did not perform originally within the deadline has to be performed now within the deadline for the application. So you have a limited period of time to make leeway for the thing which you originally missed. If you did this already, the reinstatement can also be granted without explicit application. So you do not need to mention the word, I hereby apply for reinstatement. If you explain that you missed the deadline without your own fault, if you do things which you should have done within the deadline for an application, then the whole circumstances make clear that you want to be reinstated into your lost rights, and then one cannot reject that application because the word application is missing. Makes sense. If 1 year has passed since the end of the deadline, which was missed, then the legal certainty for the fiscal administration is increased. Then a reinstatement can not be granted anymore, or you are not allowed to take that action which was missed anymore, apart from cases where this was not possible before the end of that year due to act of God, so to absolutely unavoidable circumstances. For example, Um, the fiscal office and your own home were both completely destroyed by an earthquake. Um, you woke up in hospital after a year, you lost everything, and the files in the fiscal office have, after that earthquake, burned down. So, in that case, one might think about application for reinstatement was not possible due to an act of God before the end of that 1 year period. In principle, the fiscal administration will always bring forward obstacles which you suffered from were not an absolute act of God, not absolutely unavoidable. And in the end, naturally, you have to decide or to regulate who decides on if reinstatement is granted or not. That would be the fiscal authority, which has to decide over the objection or so. And what happens if you are not happy with the decision? Well, you can then object or go to court against that. What could be done? So, conditions for reinstatement are, as we have seen in 110 AO, the action which is due must be missed without your fault. You have to make an application within 1 month after the obstacle fell away. The facts must be made plausible and the missed action has to be performed within the deadline. In that case, reinstatement has to be granted. To illustrate that, here a small example: taxpayer 7 has to hand in an objection against the tax notice before the 30th of April, 24 o'clock, so midnight. Now he hurries up the stairs, falls down on the snowy stairs, loses consciousness, later wakes up in hospital and gets informed that during he lay unconscious for 3 weeks, he always shouted in his sleep, "Letterbox, let me go to that letterbox, don't hinder me, let me go to that letterbox." Now that's evidently a case where the taxpayer was hindered from putting the letter with the objection into the letterbox in time. Only on the 2nd of June he is released from hospital. And now on the 7th of June he writes a letter to the fiscal office, explains the situation, encloses an attestation of the hospital that he stayed there from 30th of April to the 2nd of June, enclosed objection letter, asks for retroactive extension of the deadline and then waits for the reply. Now, extension of a deadline is a nice attempt but not allowed, because the fiscal office is not allowed to extend the deadline or prolong it, which has not set on its own. This deadline was set by law, so extension is not possible. But now, as an application has to be interpreted not according to its strict wording, because according to what the taxpayer evidently meant and really wanted, it is to be assumed that this is an application for reinstatement. So, check 110. The deadline for an activity was missed. That was not taxpayer's fault. Slipped, fell down, woke up in hospital 3 weeks later. That was an obstacle to arrive in time. According to his usual plans, it should have been possible to hand in time. He was 1 hour already early, so that could have and should have worked under normal circumstances. It is not his fault that unforeseeably that accident happened. So, yeah, there was an obstacle. Now that obstacle fell away on the 2nd of June when he left hospital. And now you cannot expect under reasonable circumstances that now, after you arrive at home, everybody at the first thing sits down at the typewriter and writes an application letter. So that is the reason why the law gives you 30 days after the obstacle fell away. And as this is a deadline again, you have to compute it according to the legal rules. So you left hospital on the 2nd of June, so at that time your obstacle fell away probably. So at the end of the 2nd of June, 13 hours and 17 minutes, or 13 hours and 20 minutes, too complicated. So the beginning of the deadline is always shifted to midnight of the same day. So taxpayers' deadline starts at the end of the 2nd of June and then takes a full month until the end of the 2nd of July. So taxpayer has time to act from the beginning of 3rd of June, 0 o'clock in the night, to the end of the 2nd of July, 24 o'clock in the night. The application was made on the 7th of June, so within that deadline. The missing action, handing in an objection, was performed within that deadline too. The facts which make plausible that you have a right to reinstatement were presented in a plausible way, yes. And told to the fiscal office, and certificate of the doctors was enclosed. That is making the facts plausible enough. So reinstatement has to be granted, and our taxpayer has to be treated as if the deadline had been kept, and so the objection will be accepted. And that does not mean, by the way, that the fiscal administration will then automatically say that the objection is given into, but then they will read it and debate about it. If the deadline was missed, then you get a letter that it was too late. So irrespective of what you wrote, that they are not even willing and not even allowed to even read it and comment the contents, because it would make no sense to debate the correctness of the contents if you are no longer allowed to give in to what the taxpayer brings forward. So that's the distinction between if an objection is permitted, admitted. Yeah. So if it can be accepted at all, and then if the reasons which you bring for your objection are really convincing, so that you can, as a tax authority, give in to the objection. Two different logical things. The first thing is, if you are late, we are not even allowed to read and comment the contents. Sorry, objection no longer permitted. Forget about it. If it is permitted, then the second step is we go into reading the contents and think about if it's convincing or not. That's completely different steps. By the way, if you ever read a published court decision, there is the same problem. A judge has a function to create legal certainty and keep up peace. Now, to make the wrong things right again, as far as this is possible. And now, as there are deadlines for a court application too, it would make no sense if a judge enters a discussion about what you bring forward if he's not allowed anymore to give you a court decision in your favor. So if the deadline is over, the court decision will just be your application to court is dismissed as inadmissible due to your missing of the deadline. We are sorry. There will be no single comment on the contents, because it would not make you happy to read on 20 pages that you are absolutely right, and then to get the basic and last information, sorry, but you were beyond the deadline. And it would also be a waste of time of the judges. So the first thing a court decision or a decision on an objection will always be, is your objection or is your application to court still admissible? Are the deadlines kept? And only afterwards the court or the authority will begin to comment what you wrote about. Good. Which consequences should an objection have and which ones not? That's also to be debated and regulated. Under German law, and I forgot to place that here on the slide, under German law, an objection has the consequence that the whole administrative act is just pending and can be changed in the complete extent. So when you once filed an objection against your income tax notice of 2020, that's only one decision. How high is your tax? And the rest is only reasons. So when you once brought forward an objection, the whole thing is pending, and it can be changed in any direction with any argument as long as the objection procedure is still going on. So the fiscal authorities could even dig up some future or other arguments which lead to a higher tax. You could dig up new arguments which lead to a lower tax. You could even demand a lower tax than you demanded in your first objection letter, because as long as the objection procedure is still going on, everything can be debated freely and openly. There is no really binding effect. But now let's come to another aspect, payment. In many fields of law, an objection hinders the immediate execution of the decision by the authority. For example, if the city authority says you have a building there which was erected without proper permission of the relevant authorities, so you have to tear it down. You could object against that decision, and if you object, you don't need to tear it down until over your objection there has been a definitive decision by the authorities of the court. That makes sense, because if you would have to tear down the building and later you get the information, yeah, your objection was absolutely right, it was illegal to order you to tear down that building, then that wouldn't help you anymore. So usually an objection suspends the legal effect of an authoritative, of an administrative act, but not in the field of taxation. In the field of taxation, the rule is just the other way around. Just filing an objection does not hinder the execution of the underlying administrative act. So if you are ordered to pay and you think the decision is wrong, you still have to pay. And then if you win, you get back the money, probably plus interest for the time where it was at the fiscal office without legal reasons, but you have to pay first. The reason for that is simply that if you regulated this otherwise, like in the other fields of law, if an objection could hinder the immediate validity of or immediate execution of such an administrative act, we would all file senseless and unreasoned objections just to achieve a delay in the due date of our tax liabilities. Would be a very nice trick. And as the fiscal authorities know about the human mind, they said, no, that's not possible. If somebody objects, he nevertheless has to pay, because we fear there would be unreasonable objections. Now the legislator said, but there might be cases where really it springs to our mind that the decision was wrong. Would it be then rather harsh to force the people to pay? And so their solution was they instituted a second possible application. You can apply separately for the delay of the execution of the decision in question. That's called Aussetzung der Vollziehung, suspension of execution. And then on that additional application, the fiscal authorities can decide to grant you a postponement of the due date until they have finally decided over your objection. And they are held to give in to your application and to grant the extension if your objection raises serious doubts in them if their own decision was correct. By the way, that's a very rare case. But indeed, if the idea was, if you don't bring forward a senseless objection, but if it's sound and if it's really reasoned in a way that they begin to think about it, might be possible, then you can successfully apply for a delay of the execution. Otherwise, not. You could also renounce on that application, pay, and later take the repayment, the refund, plus interest. It's also a nice investment alternative. So that's your decision. Another important field of procedural law questions is under which circumstances a legal authority is allowed to change a former decision without a previous objection. The idea is you should be able to rely on what an authority tells you so that their decision is correct and will not be changed. You must know which money you can spend and which one not. So only in rare cases a change of a decision is allowed, and the effect of that must be regulated. So it would not be possible to allow them to always change their mind. Again, we have lowered your tax next month. Oh no, we have decided to increase it. We overlooked again something which is legally in your disfavor. Next month, okay, we overlooked something else. Please give us an additional 1,000. No, that's not possible. Under which conditions should they be given the right to change the tax? Well, for example, if you have hidden facts, committed tax fraud, that shows up, is detected, then naturally they must be allowed to draw consequences. Or if new information arises, which was not known when the original tax notice was made, that would also be a reason, an excusable reason, to change a tax notice. Because they did proper work when they issued the first tax notice, they could not take into account facts which were not yet known, and so it's an admissible excuse if they later give an improved tax notice. And you also should decide when they should not have a right to change their decision. So there are some basic principles when a change is allowed, and there are special rules for tax notices. In German law, for example, there is a rule that during the assessment period, so-called mechanical mistakes or evident mistakes like typing mistakes, calculation mistakes, pages of a document simply overlooked, and other mistakes of a purely mechanical nature, where no legal ideas are beyond that mistake. So no misapplication of the legal rules, but just something overlooked, a slip of the pen or similar things. When that becomes evident and there is no other explanation than such a mechanical mistake, that can always be corrected until the last moment. Under certain circumstances, certain decisions can be withdrawn, that is, if they were wrong, or they can be revoked. For example, if the fiscal office was permitted to allow you something, it also had the choice to not allow it, then that would be a legally correct decision what they made, but they could change their mind and say, we change our decision, we revoke the decision. That is only allowed under certain circumstances. So, in case of a tax notice, the very general ways to withdraw and revoke a decision are not allowed. The change possibilities are far more restricted. There is a list in 107.8.0 and the 4 following chapters which just enlists the possibilities under which you can still change a tax notice. New facts or new proofs, 173.8.0, which show up, allow the fiscal office to change a tax notice. But if that is new facts in your favor, then only if it's not your fault that they didn't show up in your first tax declaration or when the first tax notice was made. That is just to prevent that taxpayers make it a hobby just to apply for a tax notice and then send in more and more documents. I have found an additional proof for deductible costs. Next month, sorry, I require a change in my favor of my original tax notice again. I have forgotten some additional 1,000 of the business expense. And so you could keep them busy and take revenge for your money. And so that's only possible if it's not your own fault. Fiscal authorities usually think it is your fault. That's most convenient for them. So you would have to prove that the new facts were really not known to you, or that they were overlooked. Was really not your fault at the moment when you made your tax declaration and debated the first tax notice. Okay. Contradictory assessment of the same situation in different tax notices. For example, if in year 1 million is treated as a revenue of year 1 and so taxed, and in year 2 it's now treated as a revenue in year 2, and if you complain, tax officer then says, well, last year I made a mistake. That was not a case for the 10 years roll. It was paid in 3rd of January of this year, so it belongs to this year. And unfortunately, last year that was wrong. I see that now, but I have to decide according to the right rules of the law this year. So it belongs to this year. Now I tax it this year, and last year, sorry, objection period for last year is over. Then that would be a very, very good trick in their favor, and that would be a case where the change of the former tax notice is naturally still allowed, because otherwise it would be really too easy and could get promoted probably from tax inspector to fiscal ministry of a country if you always did that trick on taxpayers. And I tax that wrongly this year, and next year I tax it again, and nothing follows because you forgot to object last year. Would be very, very nice and is not allowed. 175 AO changes which are caused to the change or the first issuing of a so-called basic assessment. For example, you remember that partnerships profits are computed or decided on in a separate procedure, in a so-called separate and uniform assessment. And that is then the basis for your income tax assessment. Now, if somebody changes that uniform separate assessment of the partnership's profit, then naturally that change must be able to be taken over into the individual tax notices of the partners. That is 175 AO. And sometimes even there are events with retroactive effect. For example, in the Restructuring Tax Act, the Umwandlungssteuergesetz, sometimes the fiscal authorities renounce on taxation under the condition that you don't do certain things within the next, let's say, 7 years. Now, if you later do these things, then naturally it must be allowed for them to change the underlying tax assessment, because now you changed the situation, you broke a condition, and so the legal conditions or the facts legally counting for deciding have changed, and they must be able to draw that into, or to take that into account. An additional change possibility has been implemented in 175A AO. Mutual agreements under a double taxation treaty or similar rules enable a fiscal authority nowadays always to change a tax notice in accordance with the mutual agreement, because somebody found out the mutual agreement is not a new fact or a new proof, it's just a decision. And so one needs to be enabled to follow it. And sometimes there are automatic data transfers, and also the data coming in from there should enable the fiscal authorities to exchange. Yeah. If you want to inform yourself more deeply about that, there is a very nice official translation, sometimes very complicated, but that gives you a good impression. The language is the same complicated level in German too. But there is an official translation of the General Tax Code, the AO, on the famous site Gesetze im Internet. That's the official site where the Ministry of Law published German laws, and for selected laws you have unofficial translations in English. They are not legally binding, the German text counts, but at least that is the translation which the ministry regards as sufficiently exact. So if you want to take that link here into account, that is Gesetze im Internet /English _underline AO index HTML, or if you go to Gesetze im Internet, then select the bar translations and select AO, then you also write there, and then you can have a first-hand impression of how the procedural law rules in Germany are. Thanks for watching. Wish you the best until you come back to this channel, and hope you share the video with others, convince others also to inform themselves in German law and international law here on this channel. And well, just imagine some other nice words, some blah blah at the end. Now come down, recover well, and see you soon back again. Sorry, and okay, and ciao.